So we're on the record in docket 2201-288. That is People of the State of Michigan versus Sharita Walters. Will the parties please introduce themselves for the record?
Good morning, Your Honor. Kristen Rolfe on behalf of the people.
Good morning, Your Honor. Jared Austin appearing on behalf of Ms. Walters, who I understand is in custody at the Ingham County Jail. She does not appear to be here either in person or remotely, as far as I can tell.
Right, and just for the record, this is a forensic review. It's my understanding that that on January 6th, it was set for, she failed to leave the jail cell in regards to some of these issues for forensic review, that they were waiting for a bed to place her at. And my understanding from our recent update, she has been found incompetent. She's waiting to find competence, is that she is next up for a bed in regards to her forensic review. With that understanding, Mr. Austin, do you have anything for the record concerning Miss Walters? It seems like we're just waiting right now.
That does seem to be the case, Your Honor. That has been the pattern that has been established since there was the finding of incompetency by the Forensic Center. I believe last summer. It's been quite some time. She still has not been placed where she needs to be to get her much needed treatment to even restore her to competency. Certainly those are the concerns I have, but all the communication that we seem to get from the Forensic Center is that we're waiting. It seems to be a continuous pattern, and that placement never seems to come.
Right, and I don't know, this started May 27th. The first review was August 29th. Our last information from the Forensic Review Center was that next bed up is hers. So at this point in time, we'll set it for another forensic review hearing, with the understanding that if something's not done in the near future, we have to address this.
Sorry.
Anything from the prosecutor's office?
Yes, Your Honor. I hope I don't come off as coming in here blazing this morning, but I do have a request for the court. I am asking the court to show cause the Forensic Center. This is unacceptable. I mean, this court signed an order finding this defendant incompetent on August 31st of 2022. So we are, I mean, beyond an appropriate amount of time for them to begin restoration treatments to try and restore her to competency. At this point, the 15 months has been tolling since August 31st, 2022. This is a defendant that I think will take significant resources and significant amount of time to restore to competency. And, you know, frankly, the response that the court received, which I also received from a Wanda Washington Jones, who I understand is the care flow coordinator. Oh, she's next up. Well, time frame. They told me 2 to 3 weeks. They're telling the court 2 to 4 weeks. I think that they need to come in and explain themselves as to why they have not at least prioritized Ms. Walters. This is a very serious case, very serious allegations, and I think this is a person. Not saying she has, you know, more serious mental health issues, but I certainly think that they need to prioritize based on this court's order of August 31st, 2022. So I'm asking the court to set a show cause hearing, show causing the Forensic Center, Your Honor.
Mr. Austin, any comment?
Your Honor, I can certainly understand the people's position on that. I appreciate the comments by the people. I'm certainly not opposed to the people's request. I would join in that request as well.
All right. Well, I have a feeling that I'm gonna set it a month out. I have a feeling she's gonna find a bed in a month. Okay, that's my feeling on this. But let's
the gentle nudge might be needed here, Judge.
I have a feeling on this. Let's set it for show cause, for an explanation as to why a bed is not available. Let's set it 30 days out. I would set it for review, but it doesn't sound like it has the weight that a show cause has.
I would agree, Your Honor.
We have an option of 3 or 5 weeks out.
Let's do 3. Well, let's do 5. Let's do 5. Let's give them an extra week.
March 17th at 8:30.
So it'll be March 17th at 8:30 for show cause of the Forensic Center as to why the incompetence order has not been followed.
With a prosecutor filing the official show cause. Check if I'm sure.
Yeah, I think I'll need the show cause from your office
Oh,
to
okay,
sign.
no problem,
Yeah.
Judge.
So I'll sign the order when I get it for March 17th. This is a nudge to make sure that they have a placement within the next 30 days. And then if the placement is set within the next 30 days, we will reset the forensic hearing and we will cancel the show cause.
Sounds good, Judge. Thank
Understood,
you.
Your Honor.
This is an assault murder, so it's not like we're dealing with a retail fraud. This is a life case.
It is, and the
Yeah,
victim.
it's assault murder and it's a knifing, I believe.
It is, Your Honor. The victim nearly died. She was, I mean, life, she had to go to the hospital and she was intubated and things of that nature. So it's very serious.
All right. So the order of the court at the forensic review hearing is to set it for show cause for the Forensic Center for March 17th at 8:30 in order to show cause why the order has not been followed. If a bed is found, we will reset for review hearing. Anything else for the record in docket 22-01288? Ms. Rolfe?
Not on behalf of the people. Your Honor.
Anything else, Mr. Austin?
Nothing further on behalf of Ms. Walters.
All right, thank you. That's all for the record.
Thank you, Your Honor.
Thank you, Judge.
It's good. Anything by Zoom. So we're on the record in docket 22-03439. That's people of the state of Michigan versus Franklin Earl Dumont. Will the parties please introduce themselves for the record?
Good morning, Your Honor. Kristen Rolfe on behalf of the people.
Erin Robinson, Assistant Public Defender, on behalf of Mr. Dumont.
And this is the time set for a preliminary examination on this file. Ms. Rolfe, how are we proceeding today?
Your Honor, I understand that the defense has a request of the court.
We're going to be requesting an additional adjournment, Judge. We're trying to get Mr. Dumont screened for drug court out in 54B. We're kind of in a situation where the first time we did ask for a screening, it appeared that the person who ran that drug court program out there left that position, and I wasn't notified until the day of the preliminary examination of that. And so a new person was brought in between then and now. Mr. Dumont had lost his phone, so he wasn't able to schedule a screening with them. He has since gained his phone and has that back turned on. He does want to participate in drug court. The prosecution and I both agree, and we're all in agreement that we think that's the best solution for him. So I think ultimately it is going to resolve in that way. It's just about getting him screened for that. So we'd be asking for a brief adjournment to get him screened. I did get in contact with her this morning, explaining the situation again and about Mr. Dumont having his phone back on. So she said that she will contact him.
Ms. Rolfe, any comment?
I just have no objection to the defense's request, Your Honor.
All right. So I will grant the adjournment. I think I'll take the next date. So 2 weeks.
That's fine.
Yeah. So, because I have this has been adjourned from December 29th. There was a fail to appear with a 48-hour hold on January 20th. So I think a 2-week adjournment for screening purposes is acceptable.
Let's do February 23rd at 9.
February 23rd, 9 a.m. for next prelim. Mr. Dumont, I'm adjourning this prelim to February 23rd at 9 a.m. If you have any questions concerning this matter or getting screened, you've already talked to your attorney, your public defender, Erin Robinson.
Yes.
So you should focus any contact calls with her. Keep your phone on and make sure you get screens, because the next time we come here, we'll make it decide on what options we have, okay?
Great.
All right. Anything else for the record in docket 22-03439?
Not on behalf of the people, Your Honor.
No, Your Honor, thank you.
Thank you.
Thank
All
you,
right.
Judge.
Good luck to you, sir.
And we're ready on Guilford. I'm just gonna go see if the victim wants to watch.
All right.
I guess. Yeah.
All right. We're on the record in docket 22-01561. People of the state of Michigan versus Asia Guilford. Will the parties please introduce themselves for the record?
Good morning, Your Honor. Kristen Rolfe on behalf of the people.
Erin Robinson, Assistant Public Defender for Ms. Guilford.
And ma'am, you are Asia Jordan Taylor Guilford?
Yes.
Okay. This is the time set for preliminary examination today. Ms. Rolfe, how are we proceeding?
Your Honor, it's my understanding the defendant will be entering a plea today.
All right. And what is the nature of that plea?
The plea will be to count 2, domestic violence. People agree to dismiss count 1 with no objection to 769 4A.
Okay, so a plea to count 2 dismiss count 1, which is the home invasion,
Correct.
and people do not have an objection to 7694A status. Is that your understanding, Ms. Robinson?
It is, Your
All
Honor.
right. Ms. Guilford, you've heard the attorney speak. Is that your understanding of the plea agreement that you're going to plead guilty to count 2? Count 1 is to be dismissed, and there's no objection to 7694A status. All right. Ms. Robinson, may I inquire of your client of her advice and rights?
You may.
All right. You understand that the maximum penalty that the court could sentence you to on this matter is 93 days under $500. And of course, there is a 7694A status. Your attorney has explained that to you. That's a part of the Killebrew. If I did not follow that Killebrew, you'd have the option to withdraw your plea. You understand that?
Okay.
Okay. So if you plead to the count to the domestic violence, you'll be giving up the following rights, and I'll walk you through those rights. All right, ma'am? You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have the witnesses against you appear at trial. You have the right to question those witnesses at trial. You, of course, are represented by attorney Erin Robinson. She could cross-examine and contest any charges brought against you by the people. Do you understand that?
Yes, sir.
Okay. You have the right to have the court order any witnesses brought in your defense. You have the right to remain silent. You have the right not to have that silence used against you at trial. And you have the right to testify at trial if you choose to testify. Do you understand that, ma'am?
Yes, sir.
Okay, if your plea is accepted, you'll be giving up the claim that this was not due to any threats or duress, or the plea agreement that you're pleading guilty because you are guilty today. Is that correct, ma'am?
Yes, sir.
You'd also be giving up the right to appeal any trial rights. Since we're not having a trial, you'd be pleading guilty in this case, and you wouldn't have any appeal rights from a trial. Do you understand that?
Yes, sir.
Okay, I'm gonna raise your right hand. Do you solemnly swear affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do, yeah.
All right. I'm gonna bring your attention back to May 15, 2022, at the offense location of East Edgewood Boulevard, City of Lansing, Ingham County. In the city of Lansing, Ingham County, on May 5th, 2022.
May 15th or May 5th?
May 15th.
Oh, yes, yeah.
All right. And in count 2, what is your relationship with Supreme Pierce?
He is my children's father.
All right. And on Edgewood Boulevard in the city of Lansing, why don't you tell the court the nature of what makes you guilty of domestic violence in this situation?
My kids were at his house and I went to pick them up and it got out of hand, I guess.
Okay, when you say it got out of hand, was there an assault in this case?
He says I punched him in his face. I didn't punch him in his face, but.
But
there was-
I'm not concerned with what he says. What do you say happened?
I didn't assault him. I didn't kick in his door. I didn't do none of that.
Ms. Robinson, did you want to spend some
Yes,
time
I
with your
can have a
client?
brief moment.
All right, thank you. You may. have the opportunity to speak to your client.
I did, and if I can question her, Judge.
All right. So we'll continue with the factual basis. Ms. Robinson, I will turn the questioning over to you.
So Ms. Guilford, on May 15th of 2022 at Edgewood Boulevard, you had an altercation with your child's father, correct?
Yes, I did.
Okay, and during that altercation, you went into the house,
No, I did not.
or well, you were at the house?
Yes,
when-
I was at the house, but I
Okay.
wasn't inside the home.
That's what I meant, sorry. So you were at the house, and during that altercation, things became physical, correct?
Yes, they did.
Okay, and you pushed, what was his name? Mr. Pierce?
Yes, I did.
Okay, and that was not in self-defense, correct?
No, it wasn't.
Anything else on the factual basis from the people, Ms. Rolfe?
Nothing, Your Honor.
Anything else, Ms. Robinson, on the factual basis?
No, Your Honor, thank you.
All right, I find the factual basis for this to be knowing, voluntarily, and accurately made. I will refer this to the probation department. For a pre-sentence report. With the understanding that we do have as part of this, no objection to 769 for a status. Date for sentencing,
April 25th at 1:30.
April 25th at 1:30. Ms. Guilford, do you plan on going to the probation department today while you're here?
If I have to, I will, yeah.
Yeah, it's probably best to get it done today, to answer any other questions today,
Okay.
to get it out of the way. And then once you do, they'll prepare a report for me. We're out to April 25th. So we're set a date on April 25th, and that's when we'll decide what our options are, okay?
Okay.
All right. Anything else for the record? 22-01561, Ms. Rolfe?
No, Your Honor.
Anything, Ms. Robinson?
No, Your Honor, thank you.
All right, Ms. Guilford, we'll see you on the 25th.
Okay. All right.
It's not gonna take long.
All right, cool.
And I should go on with the outfit.
Today. Okay, I thought that was the other day. Sorry, my bad.
Let's do. Oh, I've got. So are we ready on Miller?
We are, Judge.
All right. So we're on the record docket 22-02920. People of the state of Michigan versus Michael Allen Miller. Will the parties please introduce themselves for the record?
Good morning, Your Honor. Kristen Rolfe on behalf of the people.
Aaron Robinson, Assistant Public Defender for Mr. Miller.
And sir, you are Michael Miller?
Sir.
All right. This is time set for preliminary examination today. Ms. Ralph, how are we proceeding?
Your Honor, I understand that the defendant will be entering a plea.
And what is the nature of that plea agreement?
Your Honor, the defendant will be pleading to an added count 2, disorderly person drunk. And that's MCL 750.1671E. And that is a misdemeanor. We will be dismissing count 1, which is the CCW.
And the count 2. And
It's
that's
a 90-day misdemeanor. I'm
90
sorry.
days and or is it 500?
90 days and or $500.
$500. All right. So I'll restate that for the record, Ms. Robinson, that the defendant will be pleading count 2 to disorderly person pursuant to 750.1671E, that being a 90-day and or $500. Dismiss count 1 upon a successful plea of count 2, and then at this point in time, we're just going to refer to probation.
That's fine, Judge.
Okay. All right. Ms. Robinson, may I inquire of your client of their advice of rights?
You may.
All right. So, sir, you heard the negotiations today.
Yeah.
The negotiations are to dismiss count 1, the felony, and plead to count 2, the misdemeanor. You understand that there is an agreement that the maximum penalty for that misdemeanor is 90 days under $500.
Yes, sir.
All right. You understand that if you plead guilty, you'll be giving up certain rights today, and I'll walk you through those rights. All right, sir?
Yes, sir.
All right. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond reasonable doubt that you are guilty. You have the right to have witnesses against you appear at trial. You have the right to question those witnesses and contest those charges. You, of course, are represented by public defender Aaron Robinson. She could cross-examine or contest any charges brought against you. Do you understand that, sir?
Yes, sir.
You have the right to have the court order any witnesses in your defense. You have the right to remain silent during the trial. You have the right not to have that silence used against you. And you have the right to testify at trial if you choose to testify. If your plea is accepted, you'll give up the claim that the plea was a result of any promises or threats other than the plea agreement that we've already talked about. And you'll be giving up any appellate rights because you won't have a trial, so you won't have an appeal from a trial. Do you understand those rights, sir?
Yeah.
This is your intent today to waive your right to those trial rights and plead guilty. Okay. I know I don't have to do this, but I do it anyway. I'm gonna have you raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, sir.
All right, I'm gonna bring your attention back to October 25th, 2022, at the offense location of Pleasant Grove, Wadsworth, city of Lansing, Ingham County. Were you on Pleasant Grove and Wadsworth in the city of Lansing on October 25th, 2022?
Yes, sir.
And could you please indicate to the court what makes you guilty of count 2 disorderly person during this process?
I do remember being drunk. I do remember being a little out of control,
All right,
and I do take responsibility.
okay. Was law enforcement there at that time?
Yes, sir.
Okay, and to the best of your knowledge, did you disobey any orders that law enforcement had given you while you were inebriated or intoxicated?
Not that I really recall.
Okay, but it's,
Was there a crowd there? There was a few people at that place, wasn't there?
Yeah.
Okay, and you were causing a commotion there?
Yes.
all right.
Sorry.
Any questions concerning the factual basis, Ms. Ralph?
No, Your Honor, I'm satisfied.
Anything, Ms. Robinson?
No, Your Honor, thank you.
I find the factual basis to be understanding, voluntarily and accurately made. I'll refer to probation. So probation will come and talk to you. And we will set a sentencing date for
February 25th at 1:30.
February
Oh,
25th.
sorry, April 25th.
That seemed a little,
Sorry.
April 25th at 1:30. Probation will come talk to you, answer their questions. They'll prepare a report for me, and then we'll decide what our options are, okay? All right, so April 25th at 1:30 is date of sentencing. Anything else for the record in docket 22029220, Ms. Rolfe?
No, Your Honor.
Anything, Ms. Robinson?
If I could briefly address bond, Your Honor.
Sure.
Mr. Miller having just pled to a 90-day misdemeanor, it looks like he is being held on this case. He also has a case out in 55th for which he's being held on. I'd ask for this case to be converted back to a PR bond. He's since been in, I think he understands the importance of coming back to court. He's taken responsibility for his actions. So I would ask that this case be converted to a PR bond.
It's my understanding that it was initially set at PR bond, and then the 10% bond was put in after the defendants failed to appear. Ms. Rolfe, any comment on the reduction in bond?
No, Your Honor, I leave it in the court's discretion.
All right. I think the point has been made that when it's time to come to court, it's time to come to court. So I'll reduce bond to a $2,500 PR bond, which was the initial bond set. But as you know, if you fail to appear, it just goes back to the regular bond, right?
Yes, sir.
Okay.
Yes, sir, I do.
All right. All right, so now, if you're out on this file and if you get out, report to probation within 48 hours, okay? So you should report to probation by Monday at 4, okay?
He is being held on another case out in 55th. There is a bond hearing today, so I'm not sure the results of that. but
Okay,
Just
okay.
so that probation is aware in case they obviously call him and he doesn't answer.
I'll make a good note in the file.
Thank you.
All right, anything else for the record on docket 22029220, Ms. Rolfe?
No, Your Honor.
Anything else, Ms. Robinson?
No, Your Honor.
I think you're all set. Thank you, sir. We'll see you in April.
Do you want to do Nickerson? Yeah.
We have Nickerson.
And then, Your Honor, we're ready on Nickerson and Williams as well.
All right.
I know, there's right.
Oh, okay. I thought you were like talking. I'm like, oh, no.
Aaron, you didn't know that?
So we're ready on docket 23-00264. People of the state of Michigan versus Luke Nickerson. Will the parties please introduce themselves for the record?
Hello, my name's Luke Nickerson.
Good
Ms.
morning, Your
Rolfe?
Honor. Good morning, Your Honor. Kristen Ralph on behalf of the people.
Aaron Robinson, Assistant Public Defender for Mr. Nickerson.
And sir, you are Luke Nickerson?
Yes.
Okay. This is the time set for preliminary examination of this matter. Ms. Rolfe, how are we proceeding?
Your Honor, I understand this will be a waiver.
Is that your understanding, Ms. Robinson?
It is, Your Honor. There's ongoing negotiations between the prosecutor and I about getting Mr. Nickerson screened for mental health court, and that is the plan up in circuit court.
Okay, so unconditional waiver negotiations are continuing.
Yes, Your Honor, and just for the record, Ms. Robinson is correct. We have no objection to the defendant seeking mental health court with a hopeful global resolution in circuit court.
All right. Ms. Robinson, may I inquire of your client regarding the waiver?
You may.
All right. Sir, you understand you have a right to a preliminary examination within 21 days of your date of arraignment. The preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime was committed and the identity of the person who committed that crime. You, of course, are represented by Public Defender Aaron Robinson, and she would be present to cross-examine any charges brought against you or cross-examine any witnesses on your behalf. Do you understand your right to a preliminary examination within 21 days? If you waive your right to a preliminary examination, you're leaving my jurisdiction, district court. This will go on to circuit court, which is the felony court, in order for you to go and go forward. And negotiations are to continue. It's an unconditional waiver, but that's where the case will go. You'll leave district court and you'll be done in district court. Is it your preference today and is it your choice to waive your right to a preliminary examination today?
Yes.
All right. Do the people also waive their right to a preliminary examination?
We do, Your Honor.
All right. I find the waiver of the preliminary examination to be freely, understandingly, and voluntarily made. Prosecutor also waives their right to preliminary examination. These charges will go to circuit court. Will they continue in negotiations or to continue? My understanding is there's a mental health aspect to this. That'll continue in circuit court. So please keep in contact with your attorney, Erin Robinson. She will provide you with the next date in circuit court so that we don't provide it here, so that you'll know what date to show up in circuit court at, okay? All right. I accept the waiver and bind the court over as, bind the case over as charged. Anything else on the record in docket 23-00264, Ms. Rolfe?
No, Your Honor.
Anything, Ms. Robinson?
No, Your Honor, thank you.
All right. Yeah, you'll have to sign the bind over for the file. So, Ms. Robinson, if you want to, since we don't have a court officer right now,
Sir Desiree Macon.
and I'll make sure it's on the right page.
Desiree Macon.
So we're on the record in docket 22-03237. People of the state of Michigan versus James Earl Harden. Parties, please introduce themselves for the record.
Kristen Rolfe on behalf of the people.
Good morning, Your Honor. Toby White on behalf of Mr. Harden. Mr. Harden's here with me at council table.
All right, sir, you are James Harden.
Yes, sir.
All right. This is the time set for preliminary examination today. Ms. Rolfe, how are we proceeding?
Your Honor, I understand the defense will be requesting an adjournment in this matter, so I'll defer to Mr. White.
Thank you. Yes, we have some additional discovery that I think will be beneficial to the defense for sure, and possibly compelling enough to have the case dismissed entirely. And we've been working on this, and then there was Mr. Witsey was here, and then the detective was involved, and the detective thought we were supposed to call him, and then the detective says, no, I don't call defense attorneys, and one of those rigmaroles. But at any rate, we've now consolidated the way we're going to get the discovery, and the discovery should be available by next Wednesday. And then, so if we have a date after next Wednesday, we should have enough time to process that and go forward.
All right. Now, Mr. White, have you done a substitution of counsel and an appearance?
I believe on Harden, you should have the full paperwork.
Okay, so full retain. So, oh, that was on Mr. Callwriter's case. Miss Davis, thank you. All right, so there's a request for an adjournment in regards to Mr. Harden's case for discovery issues. Response by the people.
Your Honor, I would leave it in the court's discretion, although I do see some benefit to adjourning to get the defense discovery. I believe they're pursuing some type of a possible alibi defense, which would be persuasive. The victim also is not here, so this is the case we would be writing victim list, so we have no issues with having to bring a victim back. There is no victim here today. So for all of those reasons, Your Honor, and I do believe from talking to Detective McBride that there have been a meeting of the minds as to how that evidence is going to be extracted from defendant's phone. And so I think that we are moving in the right direction. So I would ask, I leave it in the court's discretion, but I certainly have no objection to it.
All right, so we'll grant the adjournment. And so we're 2 weeks out, right?
Yep, the 23rd at 9:36.
So it'll be set for February 23rd, 2023 at 9:30.
Check one thing, Your Honor.
Yeah.
That'll be acceptable. Thank
All
you.
right, February 23rd of 2023. So that's when we'll see here in person, Mr. Harden, all right? Anything else for the record, docket 22-03237, Ms. Rolfe?
No, thank you.
Anything, Mr. White?
Only that Ms. James will be here on the 23rd.
All right, thank you. That's all for the record in the file. All right, so we're on the record in docket 22-03542. That's people of the state of Michigan versus Saban William Jackson. So the parties, please introduce themselves for the record.
Good morning, Your Honor. Kristen Rolfe on behalf of the people.
Good morning, Your Honor. Jacob Sarge, the fourth Assistant Public Defender, here on behalf of Saban Jackson. Mr. Jackson is present in the courtroom. He's standing to my right.
Okay, sir, you are Saban Jackson? All right. This is time set for this case was initially started, it looked like. And then we adjourned it for discoveries, some discovery issues. And then I was brought a motion, which I have read, to dismiss due to speedy trial violations and abuse of discovery issues. So Ms. Rolfe, I understand this is not your case that you're covering today. How would you like to proceed today?
Yes, Your Honor, that is correct. I am covering for APA Crystal Murphy. I have been asked by Ms. Murphy to request an adjournment of this court for two reasons. Number one, Ms. Murphy is requesting an adjournment because the exam was held in part, and I believe is requesting a transcript from the first part of the exam to see what transpired and what was testified to. And then secondly, Ms. Murphy is requesting an adjournment to get to the bottom of the discovery issues that I think defense has raised in this case regarding a video, whether or not that video existed, whether or not that video was deleted, etc. And so for those reasons, Ms. Murphy is requesting an adjournment.
And Mr. Sartz, your response, I have read your motion. I only have one question on your motion. Mr. Jackson is PR bonded on this file, correct?
On this file,
Okay.
correct, Your Honor.
All right. You may respond.
Thank you. The defense, of course, would object to any requests for any further adjournments at this time, Your Honor. The basis for those objections are rather straightforward. This case is a reissue. These allegations go back to June of 2018. This case was dismissed the first time on June 28th, 2019. Crystal Murphy, the assigned prosecutor on this case, re-signed the complaint on December 7th, 2022. This case was filed on December 21st, 2022. Mr. Jackson was arraigned on January 3rd, 2023. Our office filed an appearance and demands for discovery on January 5th, 2023. To summarize, the prosecutor's office has had 4.5 years to put this file together, to complete their investigation, to follow up with the prosecutor, with their detectives, and follow up and obtain all the necessary discovery. After, Your Honor, on January 20th, after I had explained at length all the problems I was having receiving the discovery from the prosecutor's office, talking about even a copy of the original search warrant, how I had not even received that, even after describing at length the supplemental discovery demands that I had filed and everything else, I still had not received any additional discovery from the prosecutor's office until yesterday. But the biggest concern, Your Honor, the most concerning thing, after the start of the preliminary examination, I received an email forwarded to me from Mr. Berman, an email from Aaron Galloway, who works in the discovery unit for the prosecutor's office, reflecting that they had the body cams, they had the MVRs, they had that discovery in 2019, but they erased them after Mr. Jackson's charges were dismissed. Your Honor, that is a serious Brady violation. That evidence is potentially exculpatory. It is material. It has been requested. It was presumably requested by Mr. Yang, but even if it wasn't, we have a direct admission that they had it, but they destroyed it. I filed a supplemental brief addressing the issues. I attached a copy of the email updating the court on all the relevant case laws that relates to Brady violations. I filed that on Monday. And to date, Your Honor, I still have not even received a written response to either my original motion or the supplemental brief. And to exacerbate this situation even further, Your Honor, APA Murphy on Sunday told the court that there was nothing missing from the file. And that was only a few days after I'd received that email from Mr. Berman, through Mr. Berman, from apparently from Ms. Galloway, informing that all these materials had been destroyed after the case had been dismissed. So, Your Honor, I do not believe a further adjournment is warranted here. The prosecutor's office has had years to follow up and get the discovery, complete their investigation, and further, there is a direct admission from the prosecutor's office that they destroyed evidence after this case was dismissed. So, Your Honor, I don't think this is a fixable issue. Respectfully, Mr. Jackson's due process rights, constitutionally protected due process rights, have been violated here due to these Brady violations, which, if Your Honor requests, I'm more than happy to address at length, which I did in my written filings. That is by far the biggest issue. Even going beyond the concerns about Mr. Jackson's speedy trial rights, the prejudice that Mr. Jackson has suffered from these delays, and further, from my view, evidence of potential harassment in terms of the timing, with the prosecutor reissuing with no new witnesses coming forward. But above all else, Your Honor, this is now a Brady issue. So while I understand and while I'm empathetic to a point about the pressures of trial, certainly, Your Honor, I've had the privilege of trying a bunch of cases in this county over my years. There is still no excuse for failing to respond to a dispositive motion that was filed in a timely manner pursuant to the court rules, failing to, being able to proceed after we talked at length about this 3 weeks prior, informing the court that there were no issues with the discovery, and an email that was sent to the court only on Sunday, and requesting adjournment again here, Your Honor, due to the issues stated previously. Respectfully, Your Honor, quite frankly, enough is enough. Mr. Jackson's rights have been violated. This case should be dismissed. This case should be dismissed for the reasons I've stated in my brief and the supplemental filings, Your Honor. Thank you.
Thank you. Mr. Rolfe, I know this isn't your case, so do you have any response to Mr. Sart's? He's filed a motion to dismiss. Do you have any response in regards to that?
Your Honor, I will just say for the record, I am in a very unpleasant situation at present. Ms. Murphy asked me yesterday afternoon to cover today's hearing, to request the adjournment on her behalf. I have her email and I have Mr. Weesty's notes from the first preliminary examination that was started on January 20th. I do not have Mr. Sart's motions, so I'm not in a position to be able to really properly respond to those. So I would just leave it in the court's discretion.
Mr. Sartz, have you had any opportunity to speak other than the emails that have been notified by the court, then the court has been a part of the court staff? Have you had any contact with Ms. Murphy?
Yes, we talked yesterday, but again, Your Honor, she informed me that she's going to follow up with Tri-County Metro, but Aaron Galloway last week said she was going to do the same thing. And I still have not received any response back, but even it's too late, Your Honor. Crystal Murphy signed that complaint on December 7th, 2022. Your Honor granted the prosecutor's office an additional 3 weeks to get their ducks in a row on this file prior to today's prelim. And here we are. And the extent of any new discovery that I've received, to Ms. Murphy's credit, copy of the original search warrant and the drug lab results that Mr. Wisty had shown me earlier. But bear in mind, Your Honor, again, these are circumstances where our office had filed 4 demands for discovery, and we had talked about this issue at length on the 20th, and I had informed the court and the prosecutor that I was going to be filing this dispositive motion.
Right. We now have a Brady issue, which is a little different than the discovery issue that started, concerning whether this whether this is negligent or intent on some level. I would like to hear from the assistant prosecutor assigned to the case who's taken this vertically. I'd like to hear that. I don't have a huge, because the defendant is PR'd on this case. And I'd like to hear this as soon as possible. But I don't know Mr. Sart's, your schedule. So I can say that a week out Thursday morning.
Oh, he's in custody. We can't.
Oh, he's in custody. That's right. He's in custody.
Let me check the doc just a moment, please.
But he's not in custody on this case. He's in custody on other cases.
But ICJ.
He is going to be before Judge Aquilina on Wednesday. Your Honor, respectfully, the prosecutor is free to dismiss. If they want to take a few months and try to see if they can salvage something, perhaps that's the better option. Because another delay after 4.5 years of litigating this issue, and this is due to Miss Murphy's own choices. She put herself in this position. She should have had these issues resolved before she even signed the complaint on December 7th. So, Your Honor, I'm more than happy to address this issue again, but after 4.5 years, and after the discovery unit already informing me in an admission, there's too many doubts about the credibility of this investigation in the first place, about the negligence. At best, this is negligence, Your Honor. So while I certainly appreciate the court's concerns, I certainly would reiterate my request for dismissal at this time. Thank you.
And I don't have a response from the motion to dismiss for speedy trial violations and abuse of discovery. My understanding was Ms. Williams was in trial. So there were some time adjustments.
I can put it for Tuesday. Now, do you want to take a swing at it? It's a vertical. If Mr. Sart's available.
So that would be next Tuesday. Mr. Sartz, are you available on Tuesday afternoon? That's Valentine's Day on the 14th.
No, Your Honor.
No.
I'm not. However, I will send coverage because at this point, I'm not really certain what else Mr. Murphy can add. She did not file a timely response to this motion. She did not choose to respond to the allegations. And even if the answer is somewhat different now, again, there's way too many questions. Feel free to schedule that, Your Honor. I'll get coverage.
All right.
Because at this point, I'm not sure what else can be decided.
Are you available that morning?
No, I'm not going to be available at all.
February 14th.
I'm not even going to be in the state on
All right.
Tuesday.
All right.
Till later on in the afternoon.
That's fair. That's fair.
But at this point, Mr. Jackson has waited so long on this.
So I'm going to set this for February 14th at 1:30.
2 o'clock.
At 2 o'clock. I'm gonna expect Miss Murphy to be here in order. It is a vertical. If Miss Murphy's not here, that'll be very telling in regards to the status of this case. But I think there's some explanation warranted for all the allegations that have been made against Miss Murphy concerning some of the activities here. I'm going to take your motion under advisement. Okay, so that the motion to dismiss is still pending. But I have questions for Miss Murphy. I know defense counsel's made allegations. I think she should have the opportunity to make some explanations on the record, and then the court will decide. She's asked for a transcript from a officer's testimony that truly was already in the report, I would assume. So that plays very little into my contemplation. What indicates on my contemplation is that serious allegations have been made, and I think she should have the opportunity to respond to them. So we'll set it for February 14th at 2 o'clock. Mr. Sartz, I respect your schedule, so if you have somebody to stand in for you, I have a full understanding of these concerns that you have, and we're setting it within a week at this time. Of course, your client is not on bond on this case. He has other bond issues on other cases. But we will address this case one way or another on February 14th.
Thank you, Your Honor.
Anything else for the record in docket 22-03542? Ms. Rolfe?
Not on behalf of the people.
All right, you're all set. We'll see you Friday. We'll see you Tuesday afternoon.
Thank you, Your Honor.
Thank you, Mr. Sards. Yes.
Violated it, so he's already in custody.
Is that a trespass? Yeah. We dismiss. Violated after we dismiss. There's nothing in the, there shouldn't be. So there's nothing to violate him on because those cases are dismissed. You give a heads up to both the administration, not that they should start. We did Nickerson already. We're trying to be so efficient. Make sure we don't. Because a lot of times this will happen right on the stand.
Okay, Your Honor, and then I think we're ready on Davis.
All right, so we're on the record in docket 22-00300. That's people of the state of Michigan versus Catra Shandal Davis. Will the parties please introduce themselves for the record?
Good morning, Your Honor. Tristan Rolfe on behalf of the people.
Good morning, Your Honor. Toby White. I am here on behalf of Ms. Davis. Ms. Davis is standing with me at council table.
All right, and ma'am, you are Cadra S. Davis?
Yes.
Okay. This is the time set for preliminary examination today. Ms. Rolfe, how are we proceeding?
Your Honor, we are prepared to proceed today. We will be holding this exam. I do have a couple of things to put on the record before we start.
All right. From the court's perspective, it's my understanding that Mr. White, you are brand new to the case as far as being retained.
Correct.
Okay. And so, and that happened today, essentially. Today and tomorrow. Today and yesterday. All right. And you plan to file an appearance?
I have filed a substitution with your clerk already, and we will follow it up with an appearance. And regrettably, we will have to go through the prosecutor's office. I can't get the files directly from Mr. Coltrider.
All right.
And I would point out that's due to a prosecutor's policy, not the public defender.
All right. So you'll be getting the file here from the prosecutor's office.
My position on proceeding today is I prefer, because memories are short,
Right.
I would prefer that we do direct and cross together.
Right.
So
I understand.
I understand that you're probably going to overrule me, but I want to put this on the record.
I understand, Mr. White. Thank you. Ms. Rolfe, what comments did you want to make before the judge rules on whether we're going to adjourn the prelim or not?
Well, first and foremost, Your Honor, the victim, our office prepared an Uber for the victim to get her to and from court. And so she is here, and we are prepared to proceed. And so I would ask the court to allow us to take her direct testimony, certainly having Mr. White review everything and then come back for cross.
All right.
Just for the record, we'll pay for the Uber. If that's
Okay. Thank you, Mr. White. It is the court. Since the victim is here, I think we should start the prelim, do the direct examination, have the testimony, and then I'll indicate to the witness that they're still under subpoena of the court, and so they're responsible for getting back here on the date in question, cross-examination, so that Mr. White will have the opportunity to look at the discovery, look at the police report, and form a cross-examination. But I don't want to waste this time, and neither does the prosecutor, of having the victim here. Let's put her on the stand and continue with the direct examination. Any preliminary matters to come besides those preliminary matters, any other matters to court, to bring to the court's attention, Ms. Rolfe?
Yes, Your Honor. Mr. Weesty at the time at the PCC did put defense on notice. The people are holding this exam today because we do intend, depending on how the proofs come out, we do intend to add 2 counts. The potential count 2, which would be CCW, and a potential count 3, which would be felony firearm, the underlying felony being felonious assault.
All right. And since we're adjourning, I don't think that'll be an issue since there's plenty of notice given. Anything else in regards to preliminary matters, Ms. Rolfe?
Not on behalf of the people, Your Honor. We just asked for a mutual order of sequestration.
All right, and I'll leave it to counsel to let me know if anybody comes in that we would anticipate as a witness in a future date. I seem to know everybody in the courtroom right now, but I'll wait to be instructed if there's anybody other than the complaining victim who will leave once they testify, will be out of the courtroom once they testify. Anything in that regard, Mr. White?
No, I appreciate that. I just point out that under these circumstances, that I don't view this testimony being given today as preserved until I have an opportunity to cross-examine.
I agree. I agree with that. Thank you. So in regards to this file, the people may call their first witness.
Thank you so much, Your Honor. At this time, the people call Jonisha Powell.
Okay, Ms. Powell, you can step right up here. I'm going to have you stand right in front of me, and I'm going to have you spell your first name and your last name for the court reporter.
Jonisha Powell, JOHNPESHA
And
POWELL.
have you raised your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes.
All right, ma'am, you can take your mask off for projection purposes once you take the stand. And I'm going to have you project to the back of the room for recording purposes, all right? Okay. All right, Ms. Rolfe, you may proceed.
Thank you so much, Your Honor. Ms. Powell, can you please state your name and spell your name for the record?
Jonisha Powell, JOHNPESHA POWELL.
Thank you, Ms. Powell. Ms. Powell, I'm going to take you back to December 16th, 2021. Were you in the area of 3501 Simpkin, SIMKEN, Drive in the city of Lansing, County of Ingham?
Yes, I was.
And what's at that location?
My residence.
And is that a house, an apartment complex, something else?
Apartment complex.
Okay. And what occurred on that day?
Well, I was outside walking my dog, taking her out to use the bathroom, and I seen basically the neighbor, which is her mom, and I asked her.
Let me stop you right there. You gestured towards her.
Oh,
Who are
Ms.
you?
Davis.
Okay. Do you see somebody that you're talking about, Ms. Davis? Do you see that person in the courtroom today?
Yes.
Can you please point to her and describe something she's wearing?
White coat.
Okay. And for the record, Your Honor, the witness did gesture towards where the defendant is currently seated. So I would ask the court for the record to reflect the identification of the defendant.
Okay. Any objection to the identification of the defendant? You, of course, will be able to cross-examine at a later date.
Yeah, just so that we don't, just a clarification.
Okay.
And that is, there's more than one Davis involved in this case.
Okay. So this is Catra Davis? Is the identification as to the person sitting here?
Right. Your Honor.
Okay. Without objection for preliminary, with that understanding, for preliminary purposes, the witness has identified the defendant.
And so so speaking to the defense's statement, there are 2 individuals involved.
Yes, it was the mom and it was the daughter.
Okay. And the daughter, is that who you're referring to today in court?
Yeah, yes.
Okay. And so let's back up. You are at your apartment complex back on December 16th. Is it day or night?
It was day.
Okay. And you, I think, testified that you were walking your dog?
Yes.
Okay. And when you were walking your dog, did you encounter Catra Davis, the defendant you identified here in court today?
I believe so.
Tell me more about that.
Well, I was outside walking my dog and I basically asked her, did they take my packages? And so then she got all rowdy and basically yelling, and then she pulled out the gun and pointed at me. It was like, I will kill you and my dog, and basically my dog.
Okay, so let me back up. So, on this day, you said you were asking her about packages?
Yeah, because my packages came up missing.
Okay, and to try and keep it straight, you're talking at this point to the mom Davis or daughter Davis?
The mom Davis.
Okay, and why are you asking her about packages? Does she live there? Have you seen her
because
before?
The mom lived there. And so I was trying to ask her, did she take my packages, because they basically, the whole building know that sometimes they could take packages.
Objection, Your Honor.
Or what?
Yeah.
Okay,
I
so,
realize this isn't crossed, but I have to object.
right, objection, hearsay, and it's not gonna be used for any substantive purposes, any rumor, innuendo. So with that understanding, you may go on.
Thank you, Judge. So you know, if I were to say mom's name is Rena Davis, would you have any reason to disagree with me?
I don't know.
You don't know her name? Okay. So when you're talking about mom Davis, though, that's the person that you say is a neighbor or lives in your apartment complex?
Used to.
Used to. Okay. So back in December of 2021, did mom Davis live in the apartment complex?
Yes.
Okay. And so when you saw her on December 16th, was she with anybody?
The daughter.
Okay, and the daughter, and that's who you've identified here in court today? Okay. So then what happens after you ask mom about your packages, then what happens next?
They basically said that they didn't take the packages and started yelling, and she pulled out the gun.
Okay, and when you say she pulled out the gun, who are you referring to
The
pulled out the
daughter.
gun? Okay, and is that the defendant you identified here in court?
Yes.
Okay. And so Miss Davis here in court today is the one that you said pulled the gun on you?
Yes.
Now, where are defendant and defendant's mom, so mom Davis, where are they standing in relation to you?
Well, I was standing by the sidewalk and they were standing at the end of the sidewalk by the car.
Okay, approximately how many feet do you think that is?
It was close, so I don't really know.
Okay, do you say under 10 feet?
Yeah.
And when the defendant here in court, when she pulled the gun on you, was mom Davis still present?
Yes.
Okay, and you still had your dog at this time?
Yes.
Okay. Were there any other individuals out in the apartment complex?
No, but I was on the phone with my friend, so she heard everything.
What's your friend's name?
Trikosi Cheney.
And that's Tricoci?
Yes.
Your Honor, you're gonna have to object to the portion that we don't know what the other lady heard. We know that she was on the phone with her friend.
Right, I think she can she's indicating who she identifies the person. That's the only thing I've heard so far.
Right, I don't see how there's an objection.
Okay, so,
The objection is the fact that she said she heard everything. We don't know what she heard. I mean,
All right.
I'm on the phone and sometimes I have to tell people to repeat themselves.
right, so I'm not taking anything as subset. I
Okay.
understand the objection, I think. My understanding is the witness is just identifying who that person was.
Exactly.
All right.
Were there any other people present at the apartment complex?
No.
Okay, and so when the defendant pulled the gun on you, where did she get the gun from?
Inside her coat.
Okay. And do you recall what hand she pulled the gun with?
No, I just know that she reached in her jacket and pulled it out and poured it towards me.
Okay, you said she was wearing a jacket,
A black jacket.
a black jacket?
What
And-
coat?
I'm sorry?
It was a black coat.
A black coat, okay. And before she pulled the gun on you, Could you see the gun?
No,
Okay. Did you see the gun? You saw her pull the gun out of her jacket,
Mhm.
and then what did she do with it then?
pointed it towards me and threatened, saying that she's gonna kill me and my dog.
And what part of your body did she point the gun at?
Basically just at me, like, just at me directly. I don't yeah, I don't really remember because, when that gun is, I was just terrified. So I didn't know what to do. So I called the police and they told me just go back to my unit until they got there.
Okay. How long would you say this entire interaction takes place?
Probably no more than 10 minutes.
You said after you asked them about a package, and then you said or I think you said she started yelling. Were both defendant and defendant's mom yelling at you, or just one or the other?
No, just first it was just the mom because she was like, basically she didn't. Why would she take a package or whatever and whatever? So yeah, I start yelling back because you're not about to yell at me. And then that's when the daughter came in. It was like blah blah, and then pulled the gun out.
Okay. And do you recall what kind of gun it was?
No, I just know it was blood. I don't know nothing about guns.
So do you not recall?
I know it probably was like a pistol or something. I don't remember. I don't recall.
Okay. Would looking at your statement help refresh your recollection?
Sure, I don't.
Your Honor, may I approach?
You may.
Well,
And I've arrowed your statement.
can you tell me what you're gonna refresh?
Oh, yeah, because
I've arrowed your statement right here. It's the second line down. Yeah, I'm sorry.
you may approach.
Thank you, Your Honor. I'm referring you to the second line down. Just read that to yourself and then just look up at me when you're done.
I just
Right,
know.
so,
So one second. Your Honor, may I approach?
you may.
Looking at your statement, refresh your recollection.
I just know it was a handgun. I don't know what type of gun it was.
Okay, so if you told the police it was a silver handgun, you're now saying that you don't remember if it was silver?
I don't remember it. It was so long ago. I don't know.
Okay,
And plus I was terrified at the time. I don't know. I don't remember.
no problem. Do you know that if it was a handgun versus a rifle?
It was a handgun. It was like a small one.
Okay.
But it was silver.
And then after, you said the defendant pointed the gun at you, what happened next?
And then, I kind of quieted down and she was like, well, you kind of quieted down, whatever. Like, yeah, you getting a gun pointed at you, won't you quiet it down or whatever? Basically get scared.
Okay, so then,
Then I called the police and went in my unit.
okay,
Say that again, ma'am.
Oh, she was like, basically you quieted down. You know how, like I told you, we got in an argument. She was yelling at me, so I was yelling back. And so when she put out the gun, yeah, I lowered my tone because I was terrified. That's why.
and then after the defendant made those statements to you, I think you just testified, you went into your apartment, and then what did you do then?
I called the police as I was walking back into my unit.
Excuse me, Your Honor. I'm getting to
All right. So you have to say yes or no verbally.
Oh, yeah.
I didn't hear the but, so just respond with a yes or no.
That's what they do.
So let's focus on me. So you said that you called the police as you were walking back into your apartment?
Yeah.
Okay, and then,
Ma'am, I'm gonna write it down for your counsel.
Okay, sorry, Your Honor.
We can't hear over the recording.
Okay, sorry, Your Honor.
Right, go ahead.
thank you, Judge. And so then you said you went into your apartment.
Mhm.
Did you have any other contact with the defendant on December 16th? Were you present on scene when the police arrived?
Yeah, they came to my unit.
Okay, and did the police speak to you?
Yes.
Did you observe the police interacting with the defendant?
No.
Okay, did you observe the police arresting the defendant?
No.
And were you looking for any of that, or were you just in your side of your apartment?
No, I was just inside my unit.
Okay. And did you have your dog with you during the entire incident?
Yes.
I have just one moment, Your Honor.
While she's processing that, not by way of cross, but by way of clarification, one of her answers, and I don't even know if it was responsive to a question from Ms. Rolfe,
All right.
but the witness said, "They pissing me off." And I don't know.
Okay. I don't know if she was referring to you at the table talking or at the scene.
I think
So
it is.
that'll be-
Just we're clear.
So that'll be subject to cross-examination. You can ask her that next.
She just did an and I think it's supposed to be a yes. Was that supposed to be a yes, ma'am?
Yes.
That I'm pissing you off?
I'm gonna just stay quiet on that.
I think we have an understanding
I got it.
of the scenario. Ms. Rolfe, any further questions?
Yes, Your Honor. So I just want to go back to try and clarify. When the defendant was pointing the gun, you said at you, but you couldn't say what part of your body. Just further clarification on that.
I was just focusing on the gun.
And I understand that. So some follow-up questions to that. Was the defendant pointing the gun like in the air or at the ground?
No,
Okay. Were there any other people around, or were you the only person around?
I was the only person.
And while she was pointing the gun at you, was she also making statements?
Yes,
And what were those statements?
I will kill you and your dog.
And how did you feel in that moment?
Terrified.
Your Honor, at this time, I have no further questions.
All right. So the court will adjourn for cross-examination purposes. You should have reports, discovery, all of that. And so we'll reset the preliminary examination now that we've started for cross-examination purposes. We have a reset date.
23rd at 2:30.
2/23 at 2:30. I'll have Mr. White check his schedule on that.
Yeah, I have Ms. James covering another matter for me, and I'm unavailable that day.
All right, so are you looking, so,
The other matters in our court. No sense.
so let's pick another date.
Friday the 24th at 8:30.
So Friday, the 24th at 8:30?
Can we approach?
Sure. I don't think you want to do it tomorrow, next week.
No.
Okay. Yeah, all right. So let's do the week after the 24th. So that would be March 3rd at 8:30. So March 3rd at 8:30. Ma'am, you are under subpoena till March 3rd at 8:30. So we expect we expect you to be here for cross-examination purposes, all right?
All right.
All right, and talk with the prosecutor's office if you have any problem in getting here, all right, ma'am?
Okay.
All right, so this is reset for March 3rd at 8:30 for cross-examination and the continuation of the preliminary examination. Any questions concerning March 3rd date or this file of 22-00300? Ms. Rolfe,
No, Your Honor.
anything, Mr. White?
Nothing further, thank you.
All right, we're all set. I'm assuming there's a no contact order in place. Let's see. So I would remind the defendant that the defendant is still under a no contact order in regards to 1,500 feet.
Thank
All right, all right. So that's all for the record in that file. All right, Mr. White, we'll see you next time.
See you
Okay,
next time.
Mr. Rolfe, always a pleasure to have you in my courtroom.
Thank you, Your Honor.
So, I gotta get fingerprints done for another,